Good afternoon, everyone. Allison Scaberg here. We are happy to be partnering again with the Weeks Law Firm and attorney Rachel Dickison today. And we're going to be talking about special needs trust and what you need to know as it relates to planning for your loved one with a disability. So I always like to go over a few housekeeping items. So if you've attended before, you've probably heard this before, but we are in webinar mode today, so we can't see you or hear you, but we know you're out there and we're glad that you're here and that you've joined us today. We're going for an hour, so if you're planning your day, you can plan that accordingly. This is being recorded, which means that you guys are going to get a copy of today's slides. So you're going to get a copy of the slides as well as a link to the recording so you can play back. And all of our past recordings, we do webinars every week on topics on planning for an individual with a disability. And all of our past webinars live on the Consolidated Planning Group YouTube channel that you can subscribe to for free. And we go deep and wide on everything. So whether it is guardianship or special needs trust, SSI, Medicaid waivers, you name it, it's probably out there. There's over 500 webinars out there that we've done. So to help you on your planning journey. I am a parent myself to two adult kids with disabilities, and I think that it's hard. Even knowing what I know, I think planning and navigating some of these things are hard. And so our webinars are designed to empower you and give you the tools and resources that you need to be successful on the planning journey. At Consolidated Planning Group, we are a holistic special needs financial planning firm. We're nationally certified as Social Security advisors and members of the Special Needs Planning Academy. We are an advisory and consulting firm, and people come to us because they want to plan for the future of their loved one with a disability and answer questions like, how much money do I need to fund a special needs trust? Who's going to care for my child when I'm gone? What are housing options in the future? How and when should I apply for public benefits? What should I do? What should I not do? Those are many reasons why people come to us. We put protection plans in place, lifetime care plans. We do a lot of transition planning. We set up ABLE accounts, and we do a lot of advocacy. And I always just like to say that sometimes there's confusion about like what someone like Rachel does and what I do. And so we get calls all the time of like, hey, I need to set up guardianship, or I need to set up a special needs trust. We're not the attorney. You need an attorney that is nuanced and folks with disabilities to set those important documents, and we're going to talk about those today. They don't do what we do, and we don't do what they do. So we're the money. I say that they're the paper, the legal documents. We got to have them. And we're the money, making sure that we have money that's going to last us the 25 to 35 years that we're going to spend in retirement, and also the 25 to 35 years that our child may outlive us once we're gone. And so careful planning goes into play, but we work very closely together, but a lot of times there's confusion on who does what. So as always, if you've attended before, you've probably heard me say that as parents with kids with disabilities, our situation is specialized. It is truly important that you work with a specialist when it comes to your planning. So there are a lot of attorneys out there, and they might say, oh, yes, I can do a special needs trust, but it doesn't mean that they know what they're doing with the special needs trust. And I'm not saying that in a rude way. They're very smart at their wheelhouse and what they're doing. There are a lot of financial advisors out there that are very smart at what they do, but they have zero background when it comes to working with people that have a disability that may be eligible for state and federally funded programs. And that is where the rubber meets the road, because we want to preserve the eligibility for our kids for these future programs, such as Medicaid, SSI, all of the Medicaid waivers. I don't care if you're attending from another state, they all require Medicaid eligibility. So making sure that we have our money in the right buckets is really, really an important factor. So when you're working with somebody that is not specialized, it's possible that they may make a recommendation that may cause your child to lose their eligibility just because they're not nuanced in that. So I always just like to make that really, really clear. And so what I tell people is it's not about beating yourself up about what you haven't done. Okay, so we've got some people on here today that have done a lot of planning. They may already have guardianship in place. They may already have special needs trust in place. They may have a financial advisor. They may have done the financial planning aspect of it. We've got some people that have done some, but it kind of got on the shelf and life got busy. And then we've got some people that would say, I would be embarrassed for you to look at what I haven't done. Okay. And so what I would say is, again, don't beat yourself up about that. You're here today. And so it's about taking those steps forward to get to where you need to be. And I am a fan of not waiting until the crisis happens, until something happens and we realize, oh my goodness, this is not in place and we need this in place like yesterday. So it's a lot easier and a lot cheaper to be planning when you're not in crisis as opposed to being in crisis. As far as, planning and transition planning, developing a future care plan, answering questions of who's going to care for my child when I no longer can or when I'm no longer here, thinking about post-high school options and vocational options, what's next. And we always suggest considering touring transition programs, partial care, and full residential care. Some of these waiting lists could be really, really long. And then from a final perspective, we're fans of making a careful consideration before naming siblings as the future caregiver. We don't really have a huge problem with a sibling being a successor trustee on the special needs trust that is going to carefully, pay and plan for care for your loved one. But sometimes the siblings, our other kids, are not a good match for being the long-term caregiver. And so when we see these appointments, it's usually because there was not a lot of planning on the front end. Sometimes it's legit because there is a sibling that's 20 years older than the other child or things like that. And then that might be something that would be a consideration. So having said that, we have some write-in questions that we got today that we'll be sprinkling those throughout. We invite you to put your questions in the chat box today. And I'm going to turn everything over to Rachel. And thank you again, Rachel, for being with us. And again, this is the Weeks Law Firm. You may have heard or talked to Tressie Weeks in the past. And Rachel is awesome and is in Tressie's firm. So, and we've had webinars with Rachel in the past. So thank you again, Rachel, for being here.
Thank you so much. So we're going to be going over the top 10 questions about special needs trusts today. So let's go ahead and start with a case study. Next slide, please. So I have a case study for you. This is not one of our actual clients. This is a situation that we see frequently. So this is Izzy. She is receiving her Social Security benefits, specifically SSI. She's also on a Medicaid waiver program. So through that Medicaid waiver program, she has the ability to stay in her parents' home. She has a lot of her resources there for her. Her parents are doing a fantastic job taking care of her. She has an active social life with her family. And so all of the planning has been done in a great way for her during her life. Next slide, please. But unfortunately for Izzy, her parents passed away. So whenever that happened, her parents didn't plan for her future. They were focused on planning for right now. And what happened was Izzy, she received all of that money from her parents and she completely lost her benefits because it did not go into a special needs trust. Because it went directly to her outright, the money was used up for her care in only 2 years. So it wasn't over her entire lifetime, it was used just in those 2 years. Now, eventually, after those 2 years passed, she did regain benefits, but she was left with only her SSI money. So she only had $943 per month and just Medicaid. She actually went to the bottom of the list for her Medicaid waiver. So we don't want this situation to happen to your family. And we're going to talk about special needs trust and how this prevents this situation from happening. Next slide, please. So we're going to talk about government benefits. The main two programs that I'm going to be talking about the requirements for are Supplemental Security Income, or SSI, and Medicaid. So for SSI, currently this year it is $943 per month used for food and shelter. And then Medicaid is a healthcare program for our young adults with disabilities they have access to. And then you might have also heard of Medicaid waiver programs. So these have different requirements, but they have additional care and services for that individual. So it could look like attendant care, respite care, therapy, residential supplies for that individual, but it's different than those two programs. Next slide, please. Thank you. So for the eligibility requirements for SSI and Medicaid, you have to have a disability determination from Social Security, and then you also have to have low income and limited resources. Now that it changes depending on what that looks like. But let's go to the next slide and I'll give you a better idea for SSI versus Medicaid. So generally, you have to have less than $2,000 in resources and less than $2,000 in monthly income. But on the next slide, you'll see that for Medicaid, it's really less than $2,000. For SSI, it's a little bit different. So for this year, it's less than $1,550 per month in income that you're receiving. So it's a little bit different than the Medicaid amount, but still we apply that general rule.
Rachel, I just wanted to mention I do have the 2025 numbers, and
Wonderful.
so what she's talking about, this 1550 is the substantial gainful amount, and basically, if a person earns more than that 1550 gross earnings per month, they say they're simply not disabled. That number is 1620 for 2025. If you're not blind. If you're blind, it's 2,700 for 2025. And then the other thing that I wanted to mention, because I know that we have people that listen in from all across the United States, the Medicaid guidelines are basically $2,000 for most states in the United States. It's not true in California. There's a few other exceptions to the rule, but the general rule of thumb is $2,000. And I always hear, I heard it's going up to $10,000, or I heard it went changed to $10,000. And there was some proposed legislation, but it never passed. So that number really still is $2,000. So I just wanted to kind of dispel that. Unless you're in California and one off with me, we're very familiar with that and the rules there. But I just wanted to mention that.
Thank you so much. So income, like Allison mentioned, can be from that individual working. It also is considered to be a shelter, cash, or any asset that can be converted to shelter. And whenever that individual is under the age of 18, the parent's income is applied to that child. So that's why frequently a lot of people will apply for SSI whenever that child turns 18 because they're considered to be their own household. The other thing to mention in Texas is that if you are receiving $1 in SSI, you will also have Medicaid eligibility. So there's something to keep in mind. Next slide, please. For income, there's something called in-kind support and maintenance. And this is when someone else provides shelter for that individual. Now, it's important to note you're going to see a lot of resources out there that say food and shelter. If someone else is providing that, that rule did change in September of this year. So there's been a little bit of adjustment for us, but right now it is if someone provides shelter. This provides a 1/3 reduction in the monthly amount of SSI. There are ways to mitigate that I have listed here, but generally you would have that reduction unless you take another step. Next slide, please. Now for resources, it's less than $2,000 in countable resources. So what is not counted is a home, a car, personal items of that individual, or 529 education accounts. So the things that are counted against them are bank accounts, uniform transfer to minor accounts if that individual is over the age of 21, or investments real estate that they have in their name and not in their trust. Next slide, please. Now, there's another program that I'm going to just briefly touch on. So, whenever a parent passes away or they start to take their own Social Security retirement, if your child is disabled before the age of 22, they may be eligible for disabled adult child. So, with this program, they can receive half of their parents' Social Security check. And after 2 years of being on this program, they can also be eligible for Medicare. They can actually receive Medicare and Medicaid at the same time. So this is a great option for some of our families.
I just want to chime in here because a lot of people, when they're switching over, they get a denial of saying your Medicaid is ended and they're panicked because maybe they're getting a Medicaid waiver. You just have to fill out a new a new Medicaid application, and it needs to be told that it's MEPD DAC Medicaid. And so, although I've seen it where other people didn't have to reapply and things went smoothly as they're supposed to go, for the most part, people are having to reapply. So you can anticipate getting that denial of Medicaid ending when you switch over from the SSI benefits to the childhood disability benefits. But one thing I also wanted to mention here, Rachel, that's really important is a strategy of when you're going to turn on your Social Security retirement. I know that some people have died and there's survivor benefits in play. And there's, other people are disabled, and so those benefits are already in play and you can't help it. But when you can help it, as far as turning on your Social Security retirement benefits, it is best for them to qualify for SSI and Medicaid first before you turn on your Social Security retirement benefits if you can help it, because there are laws and provisions in place that will allow them to keep Medicaid even though their income may be over the guideline when they switch over to childhood disability benefits. So I said all that to say, we have entire webinars on this, but I said all that to say that it's important to be strategic, because we want them to maintain their Medicaid eligibility, even if they're on their group health insurance, your group health insurance, even if in 2 years they're going to be eligible for Medicare, because all of the waivers require Medicaid eligibility. So it's really important to understand that. And there are some other ways around it, because the Medicaid waiver income is much higher. It's 300% of SSI. So if they come up on a waiver list, if you've already turned on Social Security benefits or Social Security disability, or there's been a death and there's survivor benefits in place, you can't help any of those things. But the saving grace later is when they come up on a waiver list, then they will qualify for Medicaid. That's a different Medicaid program, and they'll likely qualify for Medicaid at that time. So I just wanted to mention that.
And then talking back about the Medicaid waiver programs, there's complete other webinars that only talk about Medicaid waiver programs. The big thing I want to hit on today is that if your child is not on the wait list for Medicaid waiver programs, you want to have them on that wait list as soon as possible so that they have their place in line. But I would refer you to look at those other presentations about the different types of waiver programs and what might work well for your child. Next slide, please. Now, there are two programs that are not needs-based. So those are SSDI or Medicare, meaning that they don't have the same income restrictions that we're talking about with SSI and with Medicaid. Next slide, please. All right, now a question that we sometimes get is, do I really need to apply for government benefits? What is the benefit of this? Keep in mind that we don't know what government benefits are going to look like in the future. So you want to maintain that eligibility for your child. The other thing is the access through those Medicaid waiver programs that have a lot more resources for your child. Typically, you have to be eligible for Medicaid. You have to meet those requirements. So you need to make sure that you have this set up. Even if you don't think that you might use it all the time, you might still want to be on that Medicaid waiver list. So think about the best way to leverage your assets, have the options open for you and your child.
And also, some of these Medicaid waiver budgets are huge. So, I think a lot of times people erroneously think, when you think of Medicaid, you think of poor, and that is not the case. I mean, there's so many programs that are not necessarily that. There's MDCP, there's these Medicaid waivers. And when we talk about these budgets being big, I mean, the whole point of the waiver is to pay for home and community-based services and defray some of the cost of out-of-pocket expenses that you may have, depending on the waiver. Some of them pay for housing. A lot of them pay for various therapies. Some of them pay for minor home modifications. So there's a lot of things that those waivers pay for. And what I would say is it's not nothing, and it's not necessarily what you think. And I would say for as many people as we have on here today, there's people on here that are already getting a waiver. There's people on here that know people that are getting the waiver. And I think defraying some of those costs and out of pocket expenses, especially if they may have care needs 25 to 30 years after you're gone, I think that that's why it's an important consideration.
So thank you for that. All right. So what makes a special needs trust special? So the big thing is if your child receives a large inheritance outright or they receive money outright that's in their name, it will disqualify them from those government benefits. So we want to make sure that we have a plan in place for that child, not just so that they can meet the eligibility requirements for government benefits, but also so you can set up a blueprint for your child overall. So, how do we do that? Next slide, please. So, a special needs trust is not a countable resource. It's not going to count against your child as a resource for Medicaid and for SSI. You have to have the proper provisions in it, and you also have to have the trustee distribute those assets properly. The desire of this is to supplement government benefits. So you have the government benefits, but the special needs trust is used for everything else to improve your child's quality of life. Next slide, please. Additionally, distributions are not income to the child. So for a trust, what is a trust? So a trust is setting up the people that are involved in your child's life after you pass away, but also having the money all pulled in one place for your child. Next slide, please. So benefits are not the only reason for a special needs trust. That's a main reason that a lot of families do set up a special needs trust. But something for you to know is that the special needs trust provide flexibility for change circumstances. So say that your child is able to work, they're really going out there, they may not qualify for government benefits at this time, but you're not sure what's going to happen. This trust can operate as a typical trust, and distributions can be made for their health, education, maintenance, and support. So this trust will be flexible for your child with disabilities. If they are not needing to apply for government benefits and not be eligible, that's fine. The trust will still work for them. But if they need to apply for government benefits, then the trust will operate for them as well. Next slide, please. So there are two main types of special needs trusts. The first are what's called first party special needs trusts. So it's created with that individual's own money. So if they receive an inheritance outright and it goes to them in their name, it would go into a first party trust. The other ways that we typically have a first party trust are through child support and if they're saving their own earnings through working. Now, the downside of a first party special needs trust is there's something called a Medicaid payback provision. So there is a list of every expense that your child has had through Medicaid. And after your child passes away, if they have this type of trust, the money that's in the first party trust is going to go back to pay Medicaid for whatever resources and things that they gave during their lifetime to your child. This is different than a third-party special needs trust. With the next slide, please. And a third-party special needs trust is created with someone else's own money. Typically, this is the parents or the grandparents of that individual, and there is no Medicaid payback provision. So this is the special needs trust that you're typically going to hear about is setting up during your lifetime to provide for your child. Next slide, please. All right. Now, how does the money actually get into the special needs trust? There's a variety of different ways, but these are the main ones. Typically, your will say that the portion going to your special needs child goes into their special needs trust. You can also direct life insurance and retirement accounts to that child with disabilities. Also, you could have grandparents say that they want to leave a gift to your child with disabilities. They can direct it goes into their special needs trust. And then child support is another way that we have a lot of special needs trusts funded. Next slide, please. All of these resources kind of act like a funnel, and they all go into the special needs trust. Next slide, please. So I'm going to touch on this very briefly. I recommend that you talk to your planners and to your attorneys about your IRAs. So there are some additional benefits of leaving IRAs to your child with special needs. There is a longer, it's called a stretched Well, I'm not going to go into too much detail. Let me just say that it's important that you talk to your attorney and talk to your financial planner about the benefits of leaving your IRAs to your special needs child. There are some additional tax benefits for you and your planning. So I would require, or I would recommend that you do that.
And the bottom line is they changed the rules, and there's lifetime stretch rules for an individual with a disability. There are some provisions like you have to have proof of the disability by October 31st following the year of death. There are some little rules and things like that. But the bottom line is other IRAs, inherited IRAs, are required to be withdrawn with over 10 years and pay the taxes. So that's not that favorable. Whereas if you have an individual with a disability, you can now stretch it over the lifetime of that person. So that's what she's talking about, and it's a pretty favorable thing. We're at a good point for a couple of questions, Rachel. Um, One person says, I have a supplemental care trust in place. Is that treated the same as a special needs trust under the rules?
I haven't heard of it called that before. I would think that it's similar to that, but I haven't heard it
Mine
called
is actually called that. So
that.
I have frequently heard it. Sometimes they call it a special needs trust. Sometimes they call it a supplemental needs trust. And I've also heard it as a supplemental care trust. And so those, from what I've seen, are yes, and they do qualify. And there are sometimes, not often, trusts that actually, because of the wording in the trust, could be viewed in the eyes of the Social Security Administration as a special needs trust. But what I would argue is that is a slippery slope, and you want to make sure that you're working with a professional that knows what they're doing on that, because more often than not, your generalized trusts are not going to qualify for us, but as a special needs trust. So that is really important. And also, I want to say that for anybody that already has a special needs trust in place, it's really our recommendation that you have it reviewed every 3 to 5 years. The rules change, the laws change. And so it doesn't mean that you change it every 3 to 5 years, but you have it looked at to make sure that it's still in line with kind of the rules of the land. And so we did have some other questions. Some person said that they had a trust from Oklahoma. Is that still good in Texas?
Yes, that should still be good in Texas, but I would recommend you talk to a Texas attorney because there may be some provisions that we would put in there because of our local Social Security offices that might be a little bit different.
Okay, and then one person, and this person actually sent me an email, and my staff is reaching out to you to get you on my calendar. But basically, what they said is my disabled loved one has a 401k, and does that affect the eligibility for future benefits? And the answer is unfortunately yes. The 401k does affect eligibility for Medicaid programs, so it might not matter if they're getting SSDI, but it does matter for Medicaid programs. So if you're interested in Medicaid waivers, then that 401k is either going to have to be moved to a first party special needs trust, or depending on how big or small it is, to an ABLE account. And then that way it'll be a protected asset. But the unfortunate thing is there's no such thing as a rollover from a 401k to an ABLE account or to the special needs trust. It would be a taxable event to liquidate the 401k, but because of the hundreds of thousands of dollars that are at play for a Medicaid waiver, it may be worth doing that. And I'm happy to talk to you a little bit further about that, but that is a great question, and we have that come up a couple of times a year. One person said, can you repeat earlier, the disabled child should be on a waiver prior to applying for Medicare? And that's not what I said. I did put some more information in the chat box, but what we're suggesting is that the individual with a disability qualifies for SSI, Supplemental Security Income, and Medicaid prior to mom and dad turning on their Social Security benefits if they can help it, right? Because we want them to qualify for SSI and Medicaid first, because there's provisions 1619B, 1634C that basically says if the person qualified for Medicaid first and then they later switch over to childhood disability benefits when mom and dad retire, and their income would otherwise make them ineligible for Medicaid, we're not going to count that income. But it's important the steps that you take first, and it's the SSI and Medicaid first. And the worst thing that can happen, again, is you don't take those steps first, and later when you come up on the waiver list, then Medicaid would come with the Medicaid waiver. But other provisions for Texas, for instance, doing it backwards may prevent you from getting Medicaid, and it can be a little bit of a problem. Um, okay, so let's see. In a will or life insurance policy, would the person just state that it goes to the trust, or does the trust need to already be created so it's not in the same? We don't want life insurance proceeds to go to a first party special needs trust. We want that to go to a third party special needs trust, so there's no Medicaid payback. And we don't ever want to name our loved one directly as a beneficiary in anything. We want it to go to the special needs trust for the benefit of said person. And that's really, really important. And so can you talk again about the differences between the first party and the third party? Like, and you mentioned the child support, which is the big deal. So let's talk about that again.
Of course, and if you go a couple more slides, I have some more slides about the child support. So let's refresh on the first party trust. So whenever a child is receiving Medicaid, there is basically a list. They keep a track of how much money they've spent per that individual. Whenever that child passes away, if they have a first party trust, the state is going to look for payback. They want that money back that is what was used during their lifetime for Medicaid. The reason that they look for that with a first party trust is because it's considered to be that individual's own income, their own resources, and they're protected during their life, but not after their death. So they're going to look for those resources back. With child support, after age 18, child support is counted against the child as income. So you may not know this, but the child support, it can be ordered for the lifetime of that individual with disabilities. So if they're receiving the income after age 18, they can lose their SSI and Medicaid. So you want to make sure that that child support is going into a first party special needs trust. The one important thing that you need to know about child support is that the divorce decree must order that the child support is paid into the special needs trust. It needs to have that language in the divorce decree itself. If it doesn't have that, we might have to go in and modify the special needs, or excuse me, the divorce decree to have it be paid into a first party trust. And unfortunately, it's unavoidable that it goes into a first party trust.
And also, I would just like to say, if divorce is on their horizon, it's so much easier and cheaper if you get that done and set up properly on the front end. There are a lot of divorce attorneys that are nuanced and special needs, and if you're not working with one, you probably should be. And if you've already hired an attorney, then maybe you hire this one as a consultant to your attorney. It is really, really important to get it right. When you get it wrong, you're the one that ends up paying for it, and then you got to go back to the well, and it's just more expensive is my thought process on that. But this is really, really important for the SSI benefits. So one person said, can we talk more about programs that are not needs-based? Medicare is not needs-based. Childhood disability benefits under a parent's record is not needs-based. And what this is that basically the Social Security Administration is saying is if you have a child that has a disability whose disability started prior to age 22, they have the ability to be covered under a parent's record. So when you turn on your Social Security retirement, then they're going to be eligible for 50% of your record. So if you're getting $4,000 a month, they're going to switch from SSI to childhood disability benefits under a parent's record. They're going to start getting $2,000 a month because they qualified for Medicaid first. They're going to be able to keep Medicaid. They may have to reapply. And after 24 months, they're going to get Medicare. So as Rachel was talking about, then they're dual eligible, Medicaid and Medicare. And just so you guys know, I always like to mention this because a lot of people don't talk about this. When you have a child whose disability started prior to 26, you have the ability to keep them on your group health insurance through your employer past age 26. There's forms for that need to be filled out by the doctor, but if you don't know about that, you need to call the HR department. Be prepared that they may transfer you around 10 or 15 times because not that many people know about it, not that many people call about it. So they themselves that answer the phone may not know about it, but somebody at the insurance company knows about it. Somebody high up in the HR department does know about that. And I'm a fan of keeping your disabled adult child over age 26 on your group health plan. Your group health plan is always going to be the best payer. Medicaid is always going to be the last payer. And so when you have group health plan, Medicaid, it goes your health plan, then Medicaid. When you have Medicaid, Medicare, and a group health plan, it goes group health plan, typically Medicare, and then Medicaid. But it's going to give the most coverage for the individual, and it's going to be valuable. So it's worth considering and asking with your employer on that. Somebody said that they just did that. There is lead time to consider. On that, but it is important. The other thing that I would say as a parent with adult kids with disabilities, our doctors are not in network with Medicaid. So, when we get scans or other things, or we're at a hospital, that works towards the Medicaid, but the doctors that we go to are mostly not. So you want to have that better coverage so you have freedom of choice of where to take your child. Someone said, is autism considered a disability? It is. And it depends. It is. It just is. And, the severity and, how a person functions, they look at all of those things. And some people have autism and they still might be able to work some, but they may not be able to earn more than the substantial gainful amount. So that is definitely considered a disability. Let's see here. Can you give us a range of how much it might cost somebody, from a financial planning perspective, to open a special needs trust? And I know you're not the decider of all attorneys and their fees, but give us a range of what somebody might expect to spend on setting that up.
Yeah, it really depends on the package that you're going to do. I would say typically if it's just the special needs trust, you're looking at if around maybe $5,000. It could be less than that, or it could be a little bit more than that, but that's probably the average of just setting up the special needs trust with someone that has an expertise in this area. It just really depends on what attorney that you're working with.
Okay. Someone says, is back child support 200 a month for now adult kids count against only one kid? And it would count against 1/3, so it wouldn't completely like make the SSI go away. It's a small amount. It's those bigger amounts that are really going to make a difference and make somebody not qualify for SSI. There is a family maximum someone put out there, and so which ranges from 150 to 188 percent of the benefits. So when we have more than one child in a family, if we've got more than one person drawing off of a parent's record, there is a family maximum. So that 50% number of under a parent's record could be a little bit less than that. And I also should mention that when that parent passes away, that number goes from 50% to 75% of the parent's record at death. And so I did want to mention that as well. Okay, let me see if there's any other questions that are relative to where we are right now. The question about a special needs trust written 14 years ago. Again, we would recommend, we're not here to rain on any great attorneys that set this up or anything. We love that you've taken steps to do planning, but it's time to dust it off and have it looked at again. Every 3 to 5 years is a really good rule of thumb. A lot of attorneys, if they did the documents, they'll review it for you. They may review it for you for free or a very low charge. Other attorneys that are nuanced and special needs, they may review the trust as well, and for an initial consultation. So it's worth doing it. So let's talk about let's move on, from a slide perspective for now.
All right, so we're going to be talking about what the trust funds can be used for, talking about those distributions. So distributions cannot be cash or debit cards coming out of the trust, and it can't be for anything that's paid for by government benefits. Next slide, please. So there's a couple things that it can be, or there's a lot of things that it can be used for. So it can be used for distributions for their personal care, social and recreational activities, entertainment, education, additional medical expenses. But all of these things, the government benefits, what they pay for, it pays for it first. So for example, on medical care, whatever the government pays for will be paid for first from their healthcare benefits. And then the trust is used for anything on top of that, any bills that are left over.
So we had somebody in the chat box that says, what is a third party special needs trust? So that is not their money. This is the right way we leave money to an individual with a disability to preserve their eligibility for state and federally funded programs. A first party special needs trust is their money. For instance, the question about the 401k, if they cash out that 401k, that is the individual with the disability's money. And so it would either need to go into a first party special needs trust that has a Medicaid payback, or an ABLE account, which also has a Medicaid payback. So it's their money, first party special needs trust. Somebody else is leaving money for their benefit is the third party. And there is a lot of confusion with that. So thanks for asking that.
And we will be getting to ABLE accounts in just a little bit. So how the trustee can pay for those expenses, they pay them directly to the third party. They can also use a credit card that the trustee pays off each month, or something called a TrueLink credit card that's essentially like a prepaid credit card. But those are different options that you have for paying off the trust funds. Now, on the next slide, we're going to be talking about who is your trustee. So a lot of times people have not performed the duties of a trustee. This looks like investing the assets properly, understanding how the distributions are going to affect government benefits, keeping detailed financial records, potentially filing a tax return, looking at all those things. A lot of times the trustee has not done this before for someone. So what things should you look for in your trustee? So for your trustee, there's a couple different options. And on the next slide, I have a little bit more information about that. So really what we ask and say, we're looking for someone that has the ability to be reliable, have integrity, and the ability to learn the special needs trust rules. So the ones I've talked about generally, but also some more of how do we actually administer those special needs trusts. Frequently, this is a family member or a close family friend. There are also professional options if you do not have that individual in your life. There's corporate trustees, but there's other options as well. And then on the next slide, one other potential good option for you may be the ARC Master Pool Trust. They serve as the trustee and you have a sub-trust for your child. So it's a great option for a lot of families. And I'd be happy to talk to you more about that in different context if you don't have those individuals in your life. All right. Now, we also recommend that you have a trust advisory committee, especially if you have a corporate trustee. So what this is a group of individuals that know your child with disabilities well, and they're going to help recommend different distributions for your child. So it's another safeguard that you can set up in your trust. Next slide, please. Now, what happens if I don't have a special needs trust? So let's go back to Izzy in our example from the very beginning. She didn't have a special needs trust. She received all of her inheritance outright. With that, she lost all of her government benefits. They had to use all of the money up for her care so that she was under those resource limits. That is not ideal. We do not want that to happen. Some families also decide, well, I'm not going to leave an inheritance to my child with special needs. If you do that, they will just have their SSI or their any government benefits that they have available to them. It's not an ideal situation. Additionally, leaving assets to other family members, you can never fully guarantee that they're going to use it for your child how you would want to use it. So we do not recommend any of these situations. A lot of families consider this, but it is much better to have a plan in place for your child with a special needs trust instead of relying on one of these options.
I echo that 1,000%. And it's not because your other family members aren't good and that you don't love them. It's not that. It's that life happens. Look at your life. People are either going into a trial, they're in the middle of one, or they're coming out of one. And your other kids and family members are the same way. Life happens. People get divorced, people die, people get sick, things happen. And so, in a divorce or a death, it could end up in the person's estate and not for the individual with a disability. In a divorce, it could get tangled up. So it's messy, and this is called disinheriting the person with the disability. And it's a bad idea.
Right. And then what other documents might you need? So we recommend you don't just have a special needs trust, you're setting up the rest of your entire estate plan. So a special needs trust is great if you have it, but we need to make sure that money is actually getting into the special needs trust. So you need to update your wills to make sure that the portion going to your child with disabilities actually goes into their special needs trust. The same with beneficiary designations on all of your accounts. We want to make sure that it's not going to your child outright, it's going to their third party special needs trust. And I think Allison mentioned this before, but we want to make sure it's not going to a first party special needs trust, that it's going to their third party special needs trust. You also want to have a care plan for your child. So, what that looks like is if they are under guardianship, we want to make sure that you designate who you'd want to be the guardian after your child, for your child. So we're really looking at a holistic approach for your family. We don't want to do just one thing. We want to look at everything involved in your life, all the different money sources that might be available, but not just with you, also with your other family members, like your the grandparents of the grandchild. What if they want to leave money to your child and they leave it to them outright? And they have this wonderful gift for them of $50,000, but there's nothing we can do. We have to put it into a first party trust for them. That's not the ideal situation at all.
So one person says, does a special needs trust need its own bank account? And yes, like you would have the special needs trust, the registration of any investment accounts or bank accounts would be set up in the name of the special needs trust and the tax ID. A special needs trust would have its own tax ID if it's a standalone trust, so you would have separate accounts for that. And I just would like to mention, because this comes up sometimes, Rachel, um, you cannot have your SSI going to a third party or a first party special needs trust. And I've seen this mistake happen before. It is a mistake. It's a debacle and it's hard to unwind. But you cannot have SSI going to a first party or third party special needs trust, nor can you have SSI going directly to an ABLE account. It doesn't work that way. So I did want to mention that. Can you please clarify, say I have a third party trust. If I pass away tomorrow and have instructions for my life insurance to go to the third party special needs trust, where will the life insurance send the check to? To my house or to the trustee? And they would go to the bank and open the special needs trust?
So typically, this situation, your trustee that's going to take over the special needs trust would contact the life insurance company and they would receive the check and it would go into a bank account that your trustee creates or is now taking control over because they have that trust. Mhm. All right, now we're going to talk about ABLE accounts. So, an ABLE account, and I'm going to be talking generally about the Texas rules. Each state has their own different rules, but they're generally the same. So, an ABLE account can hold up to $100,000 in the account without impacting government benefits. Now, this year it is $18,000 per year that can go into the account. Next year it's changing to $19,000 because it's increasing. But you have to have a disability determination. It's different than Social Security, but you have to have that individual has to be disabled. The big thing with ABLE accounts is they still have that Medicaid payback provision. So just like a first party trust, there is also a Medicaid payback provision with these ABLE accounts.
I had a clever question on this week. Somebody emailed me and told me that they were annoyed with the Medicaid payback provision in the Texas ABLE accounts, and they know that they could get an ABLE account from any state, and they're going to pick a state that does not have a Medicaid payback. And so that was very clever, but how this works is it's where you reside. Medicaid is state specific. So if you live in Texas and you go pick a different state that doesn't have a Medicaid payback and you get their ABLE account, your ABLE account still has a Medicaid payback because you are a Texas resident and there is a Medicaid payback in Texas. Now, there is some proposed legislations to get rid of these Medicaid payback provisions, but once again, it's proposed and it has not passed. We hope it will. I'm optimistic that in the future it will, but I think what happens is it gets proposed and then it's on the table and they have so many other things on the table that they never get to it. It's not that they're denying it. It's like low on the priority list is what I would tell you. So I just wanted to tell you, if you had those thoughts, the Medicaid payback does apply. Now, another thing that I want to tell you, I have some families that would say, who cares about the Medicaid payback? the most money that could be in the account is $100,000, and Medicaid will have far paid more money than $100,000 than they'll ever get on the Medicaid payback. And then other people use the ABLE account as a savings to spend account. Because money in the ABLE account grows tax-free and it's tax-free distributions, it kind of acts like a Roth IRA, but it doesn't count against them. So some people just use it as a savings to spend account. So there's never that much money in the ABLE account to begin with. So if there's a Medicaid payback and so what, there's $5,000 in there, who cares? So I just wanted to kind of give you some of the schools of thought on that as well. So we've got, would I need an ABLE account if I have a special needs trust? This is a great question, and this lends itself to a question of basically what can an ABLE account pay for and what can a special needs trust pay for? A special needs trust and an ABLE account go beautifully together. So talk to us about that,
Yeah,
Rachel.
let's go to the next slide, or I think it's 2 slides from now. So, well, okay, let me hit on this and then I'll answer your question. So the funding limit is going to change to $19,000 per year next year. For SSI, you can only have $100,000 in this account without impacting SSI. You can still retain Medicaid. If you have more than that in the account, you can just receive Medicaid only, but you will not receive SSI. So let's go to the next slide for this. All right, so ABLE accounts, they are a great option to work with your special needs trust. So with ABLE accounts, you can use it for education, housing, health and wellness, assistive technology, legal fees. The big one for ABLE accounts is that you can use it to pay housing expenses. So this is a limitation on special needs trusts. If it's coming out of a special needs trust for housing, then you have a 1/3 reduction because of the in-kind support and maintenance rules that I talked about before. If it's coming out of an ABLE account to pay for rental expenses, it doesn't count against them. So we typically use ABLE accounts in conjunction with special needs trusts to help pay for those rental and housing expenses.
And you said something that's really important, because a lot of times people say you can't pay for food and shelter out of a special needs trust, and that is simply not true. You can pay for food and shelter out of a special needs trust. Food doesn't count anymore. I guess they decided that we all should eat, but whatever. But shelter, you can pay for it out of a special needs trust, but there would be a 1/3 reduction for SSI, but that also does not apply for SSDI or childhood disability benefits. These are two different programs and they work differently. So I just wanted to mention that.
And there are some instances where you might be receiving SSI and it might be advantageous to just take the 1/3 reduction. So you can talk to your attorney about that. I have recommended that in the past for some cases because it's better for them overall to have these expenses paid for. So just like with a special needs trust, the interest is not income to the beneficiary. Distributions are not income to the beneficiary, even if it's for the food and shelter. And something you do need to know is you will have to provide records to Social Security. This is for both a special needs trust and an ABLE account. Next slide, please. All right, so this is just kind of recapping what I was talking about just a minute ago. There is a Medicaid payback provision for the ABLE accounts, and the third-party trust does not have a Medicaid payback provision. So a lot of times what we do is we work with these in conjunction. The majority of the funds are in the special needs trust, and then we can make distributions from the trust to an ABLE account to pay for some of those small expenses that needed to happen. You
So we
can
have a
also,
question. Can
yeah,
SSI pay for rent to a property owned by the third party special needs trust? And if it's for the shelter for the individual, there's no issue with that, correct?
that's correct.
Okay.
All right, and then one other thing for the ABLE accounts, they have allowed for a 529 account to be rolled over into the ABLE account for that beneficiary if they're the same beneficiary. So this is something to talk to your financial advisor about because you might want to roll over the 529 account into the ABLE account.
And then also the provisions for the ABLE account is the disability had to start prior to 26. So I've given some numbers. Prior to 22 to be covered as a disabled adult child under a parent's record for the Social Security Administration. Disabled prior to 26 to keep them on your group health plan past age 26. Prior to age 26 for an ABLE account, except for in 2026, that age is going up to age 46. So disabled prior to age 46.
All right. So we just talked about this. The big reason that we would use an ABLE account is really for paying that rent. You can also use it for small gifts and inheritance. So say going from the grandparents, it's $10,000 that they're receiving, and that's underneath the $19,000 amount. So you can put that money, the gift from the grandparents, into the ABLE account without having to create a first party trust. So it's a good option for you there.
And I just like to mention, because Christmas is coming, Christmas, birthdays, when grandparents or somebody gives your graduation, somebody sends a check. This money can go into the ABLE account and not count against them for income for SSI purposes. But when grandma and grandpa send a birthday check, that's considered income for SSI, and they could actually reduce their SSI. It's silly, but it is how it works. Not true for childhood disability benefits or SSDI. Again, it's a different program, but I did want to mention that. So when we get a check from grandma and grandpa, if grandma and grandpa want to make it in the parent's name and then you put a deposit into the ABLE account, grandma and grandpa can put the money directly into the ABLE account. Anybody can contribute to somebody else's ABLE account. I could contribute to your kid's ABLE account if I wanted to. So it's better to do it that way than to have them get the check outright.
Yep, and that goes back to going with the whole family approach. We want to make sure that their grandparents and their other family members know what's happening so that they are taking advantage of these things and that they're not going to disqualify or reduce the SSI amount for your child with special needs.
And Rachel, we have about 5 minutes left today. So where do you want me to go on the slides? How
Yeah,
are
we
we
can
doing?
we can go ahead and end there. The only other point that I have really on the slides is the most common question we get is when to create a special needs trust. Really, it's whenever you are before you become disabled yourself or before you pass away. We don't know when that's going to be. So as soon as you're comfortable to have these conversations and set that up, we recommend that you talk to an attorney about doing a special needs trust.
And I'm a fan of sooner versus later because we don't know when the crisis is going to happen. And then the other thing is there is a such thing as a testamentary special needs trust that lives inside of your will. And it basically says that the special needs trust is going to be created upon your death. And that is okay, as long as there's no other family members, grandma and grandpa, mom and dad, other family members that may leave money to your loved one. Because if they die and you're not dead, your special needs trust is not established, and then they leave the money accidentally outright to your kid, and then you got to go get an oops first party special needs trust when it could have just been set up properly to a third party special needs trust. So if there's any inheritance that's possible, it's better to go ahead and get it set up and have the standalone trust set up sooner versus later. All right, so yep, we've got Rachel's contact information, and everybody's gonna get a copy of today's slides and a link to the recording, so you guys can kind of look through some of the things, excuse me, that we have talked about today. And their firm, they work on special needs trust. They wills and powers of attorney, healthcare power of attorney, HIPAA release, guardianship, to name a few of the things that they do. And they work all over the state, not for guardianship. Guardianship is more their area. I think there's a 2-county area and that they do on guardianship, but you do work all across the state for special needs trust. Is that correct?
That's correct. And we do a lot of Zoom consultations where we do everything by Zoom. And then we have the signing appointment. You have a notary with you, and then we're there helping you when you're doing your signing of your documents. Those 2 counties for guardianship are right now Collin and Denton. We're currently paused on taking cases in Dallas, but we anticipate we're going to start doing those again sometime soon.
Okay, perfect. All right, so these are just some things to keep on your special needs planning radar. We have webinars on every topic: future care cost estimate, Texas waivers, SSI, SSDI, ABLE accounts. But we talked about the special needs trust today. We've done guardianship, post high school options. We have housing options. It's all out there on our YouTube channel. And in our slides, you're going to get a link to our upcoming webinars so you can register for future webinars going forward. We work on a collaborative team here at CPG. Again, nationally certified as Social Security advisors, members of the Special Needs Planning Academy, and we stand ready to help you plan for your future. Our initial consultations are always free. We want to learn more about the planning that you've done so far, what questions that you have, what brings you to the table, and then we can talk about the doors that you can walk through. One person in the chat box asked about our fees, and we have several doors that a person can walk through with CPG, but in general, the plans start, I think it's about 1250 and to 3750, and it just kind of depends on where you guys are and what planning that you've done so far and what your needs are. But the initial consultation is very personalized, and we want to have a better understanding of you and what your needs are, and then we'll make recommendations from there. So again, what I would say, it's not about looking back, it's about looking forward and taking the steps that you need to be successful. The bottom line is we have a long time in retirement. 25 to 35 years is a long time in retirement. We do want to keep our assets nimble to where you have money to be comfortable in your own retirement, but we also want to make sure that we have money to fund that special needs trust, and we help with all of those conversations. So if you haven't met with us before, this QR code will take you to our calendar, and you can schedule your free personalized consultation with us. And Rachel's contact information is in the chat box, also on the slides. And again, you guys are going to get a link to the recording and a copy of today's slides. You guys asked great questions. I don't know the answer to the question of who like the grassroots group is as far as the proposed legislation, as far as getting rid of the Medicaid payback, but I know that it has been ongoing for like 10 plus years, and I think it's all across the US, but it's at the federal level. So it's just something that needs to be approved. Medicaid is a state level, but there are other federal guidelines as well. So I don't have the specifics on that. But thanks everyone for being here with us today. We're out of time for today, and we will look forward to connecting with all of you again soon. And thank you, Rachel, for being here with us today. And we'll look forward to partnering with the Weeks Law Firm again in 2025. So
Thank you.
thank you. Take care. Bye now.